Is there a time limit, sir, for this mediation process?
Yes.
So is it that in this example, the developer can say, I need 6 months time before I can arrive at some settlement. So can this process be continued for a couple of months, or is there a timeline?
The developer and his people, or whoever it is singularly, if he is coming, that's a private session. In the private session, if there is something which is very confidential and it is not supposed to be disclosed as informed to the mediator has to maintain that.
So during the process of mediation, can you tell us how exactly it happens? What are the documents? Is there any necessity of attaching any documents? Because you just mentioned that whatever settlement that is arrived at, it's as good as a court decree.
Yes.
So in the normal circumstances, we would file a lot of documents, supporting documents as our evidence. But because during the process of mediation, eventually if there is an agreement, it will be akin to a decree. Can you tell us whether in the given circumstances, is it necessary that I have to attach agreements, I have to attach communications as documents, any evidences to be submitted? Can you explain the process of mediation?
The entire process before the pre-institution mediation is informal.
Okay.
Court is a formal body. All the procedures in the court are formal. In the mediation, particularly pre-institution mediation, it is informal. Number one. What you give in application is not a plaint.
Yes.
If you have filed a plaint, then it has its own sanctity, it has its own effect. Here it is just a form. Very importantly, in a plaint you usually allege on your opposite party.
Yes.
Here it is not so. My subject matter of dispute is causing me to come to mediation. So purely there is no allegations.
There's no need to use any legal jargon.
Exactly.
As well.
So the lawyer need not have to worry, or the client need not have to worry that I have to see now what are the allegations to be made.
Yeah.
Because what happens is, if you make allegation, then it becomes difficult to mediate.
Yes.
So the form is only an information.
Yes.
Wherein he says, I am willing for a participation in mediation. The opposite party also gets only the invitation.
Yes.
He may also have the open mind to participate.
To mediate.
He also can say, I am not interested.
Yes.
The beauty of this is there is no compulsion.
Yes.
Approaching mediation is compulsory. Participating in mediation is compulsory.
Yes.
But that doesn't mean that you have to participate and get a positive result all the time.
Yes.
Agreeing to agree to mediation doesn't mean that agreeing to agree for settlement.
Yes.
That's important.
So there is a party autonomy for both.
Exactly. Party autonomy is there and the liberty is there. Right to withdraw is available.
Yes.
The defendant can look at the invitation of mediation and say, no, I don't want.
Yes.
He is not bound. It is only an offer of invitation. He may skip. Or he may say, okay, let me try. Just because he has approached mediation doesn't mean he has to compulsory have a settlement.
Yes.
It is like, I walk into a, showroom, ready-made showroom. Just because I've entered, it doesn't mean that I'm committed to buy.
Yes.
I may look at all the varieties of cloth,
Yes.
say thank you very much and come back. Same thing as this.
Is there a time limit, sir, for this mediation process?
Yes.
So is it that in this example, the developer can say, I need 6 months time before I can arrive at some settlement? So can this process be continued for a couple of months, or is there a timeline?
There are two aspects when it comes to time limit. The duration of the mediation, that is pre-institution mediation, is minimum of 3 months.
Okay.
From the day when you lodge your application for mediation,
Okay.
Form 1 we call it, before the TLSA.
Okay.
3 months, that is to say the other side has to appear, he will come, and within 3 months. By consent of the two of the parties, it can be extended by 2 more months.
Okay.
That is to say maximum of 5 months. This is one aspect. You say that the developer wants more time to pay.
Yes.
That has nothing to do with this.
Yes.
Settlement has to be within the 5 months.
Okay.
In the process of 5 months, he may say, sir, I have no money. I wish to get money, say by December 2024. So I would pay it in December 24. So give me time after that. That's a settlement execution.
So that itself can be recorded as a term of
That
the
becomes a term of the settlement.
Yes. Yes.
And it's enforceable.
Yes.
Enforceable as if it is a judge who has passed a judgment on merits of the case. That's the beauty of this.
Yes.
So pre-institution is a mechanism where parties themselves get a judgment of their own choice.
Yes.
They decide the terms of the settlement. They decide what is that they want, and they avoid the court. So by this, the threshold rush to the commercial court is reduced.
Yes.
If there are 10 disputes which are going to come, Thanks to this concept of pre-institution, maybe that would be reduced to 4 now.
Yes.
Because that 6 of them may find pre-institution effective and get results.
So you mentioned that there is a party autonomy during this mediation process. So let us consider a situation where both parties genuinely try to resolve their disputes, but somehow they're not able to conclude. So if during the process they have revealed certain confidential information and eventually the parties decide they want to back off the settlement, so can any discussions which have happened during the mediation, any documents which have been produced before the mediator during the process, can that be taken to the disadvantage of the other party before the court?
Yes, it's a good question. What transpires in mediation is protected by confidentiality. The mediator cannot reveal what has been told to him in confidentiality. Mediator later, after the mediation is over, can never be acting as an advocate for any of the parties because he has been wearing a hat of a mediator.
Yes.
And in the process he has been privy to some information. He can't now go back and say mediation is over, now I'll switch on to become a party, advocate for a party.
Yes.
That's also confidentiality.
Yes.
Some documents may be crucial.
Yes.
That may be reserved by a party saying that I do not want to reveal it in the mediation. Mediator has to ensure that such a document is not disclosed to the other side.
So do you mean that a party can ask for a one-on-one discussion with the mediator during the process?
The mediator can have joint session where both the contractor is there and the developer is there. Mediator may have only discussion with the contractor, maybe his colleague, maybe his family member, maybe his friend. Similarly, the developer may involve himself, maybe the managing director, purchase manager, or whoever is irrelevant. So, contractor and his people, it's a private session. Separately, the developer and his people, or whoever it is singularly, if he is coming, that's a private session. In the private session, if there is something which is very confidential and it is not supposed to be disclosed as informed to the mediator, mediator has to maintain that
Confidentiality.
He has to protect it.
Yes.
What he says only should be said. What he says don't say should not be said.
We spoke about a situation where the mediation happens successfully, where both the parties will amicably resolve all their disputes. We spoke about a situation where the mediation would fail because the parties are not coming to terms of their understanding. So can there be a possibility that once there is a suit which is filed before the commercial court after the settlement has failed, during the process of trial before the commercial court, one party or rather both the parties can again decide to go for mediation?
Possible. That's another good opportunity. See, a commercial dispute is already pending in the court. One, probably the parties have already had a pre-institution mediation in that.
Yes.
Yet there was no settlement, so that resulted in the parties going before the commercial court. In the commercial court, maybe after some time they realized probably they had an opportunity which could have been availed.
Yes.
Now they realize that probably they can still try.
Still try.
They can always come to the court, mediation. Advantage is, sometimes they may say, okay, mediation we have already seen as a pre-institution. Maybe that we'll try arbitration.
Okay.
Maybe we'll try conciliation. Maybe we'll try Lok Adalat, that is to say Legal Service Authorities Act, or maybe mediation. So all 4 options come. So please see the difference. Earlier, before the law of commercial court came, every dispute which is filed was under section 89 of CPC was referred to one of the alternatives.
Yes. Yes.
At the choice of the parties, arbitration, conciliation, mediation, Lok Adalat or judicial settlement. Now, only for the commercial court this pre-institution concept is introduced.
Yes.
That doesn't prevent the commercial court to send the parties again to mediation or to any other mechanism. So that again opens up. The parties who have already had tested this mediation, but for some reason they are not settled, may get another opportunity now to correct their mistake or revise their offer and try again for a mediation. Because they were in the meantime in the court, they know what exactly is the scenario in the court, how serious it becomes. So pre-mediation helps for the mediation settlement.
Yes.
That is possible.
Yes.